GBI has arrested Colin Gray, age 54, in connection to the shooting here at Appalachia High School. Colin is Colt Gray's father that was arrested yesterday. He is charged with the following: 4 counts of involuntary manslaughter, 2 counts of second-degree murder, and 8 counts of cruelty to children. Mr. Gray, these charges stem from Mr. Gray knowingly allowing his son, Colt, to possess a weapon.
So a lot of developments just in the past 24 hours in this case, this horrible tragedy coming out of Georgia involving this 14-year-old who killed 4 individuals, 2 students, 2 adults there in Barrow County, Georgia. Welcome back to the program. Dana Loesch with you. Bottom of this second hour. It's something we've talked about, just the latest developments quite a bit. And then this charge came out last night against the dad. And you heard law enforcement there detailing some of this. A lot of this is being compared to the Crumley case in Michigan, where that killer's parents were just convicted, I believe, last April for essentially culpability in the murder of other innocents by their son. And I know that there are, on its face, it looks like there's some similarities in these cases. I think that there are some big differences, obviously, in these cases. But it does bring up a very compelling question. Should parents of these, minors who are murderers, are they liable? I know there are negligence laws and things like that that come into play. But there have been a lot of criticisms about the Crumley case and the way that the prosecution argued that. And so I wanted to talk to a legal expert about this, our friend Andrew Branca, who you can find on X at Law of Self-Defense. He is a self-defense attorney and a legal expert, lawofselfdefense.com. Andrew, I really appreciate you joining us on this. I kind of wanted to get your thoughts on, the charges for the dad. A lot of people are comparing it to the Crumley case. I know I've read a lot of criticism of the way that case was prosecuted. Is this the new precedent? Are we charging parents, and is that in this particular case the right legal pathway?
Well, so parents are not automatically criminally responsible for everything their kids do. That's not the way the law works. The parent has to have some independent criminal culpability in order to be held criminally liable. And it's not hard to imagine how that could occur, right? Imagine you have a teenage son and you're sitting with your son and you're both getting drunk at the kitchen table. And he says he wants to drive to go see his girlfriend. And you say, here are the car keys. Go ahead, son. I know you're drunk, but you go ahead and drive the car. And then he runs somebody over and kills him. You would have culpability there. You know he's intoxicated. You know he shouldn't be driving. You're facilitating his ability to do that. I think we would all agree the parent there would bear some criminal responsibility. That's different than if the kid just sneaks around and grabs the key and the parent doesn't know. Right? Those are 2 different fact situations. In these cases, we're talking about allegations where the parent is claimed to know the child is violently unstable and provides that child with a gun, and then the child uses that gun to kill people. That's the parallel there to the affirmatively allowing the kid to drive drunk. Now, I know why people in the Second Amendment community, gun owners, are very sensitive about this, because we know the gun controllers will come up with any scheme they can imagine, whether based on legal merit or not, to punish gun owners. So we want to be very sensitive. We're not falling into a trap being laid by the gun control community. But the fact is, it's possible for a parent to be engaged in reckless culpability, knowing culpability for misconduct they have reason to believe their kid is going to engage in, and then providing the kid with the tools to do that. So the involuntary manslaughter charges here, if the facts support it, the prosecution has to prove these facts beyond a reasonable doubt. The involuntary manslaughter charges don't really surprise me if the father actually provided a son he knew to be dangerously unstable with the gun he used to commit those killings.
Is that a tough thing to prove if you're the prosecution and you're looking at whether or not this parental carelessness is meeting the litmus test for criminal negligence? I mean, that there has to. I mean, they really. It seems like a tough thing to prove if you're the state.
I mean, it depends on the facts, right? So if the parent knows the kid is dangerous, but he's keeping his guns locked in a real safe, and the kid had to cut open the safe with a torch to get to the guns, well, the father took reasonable steps there to ensure the kid couldn't take the gun. You can't stop everything.
Right.
But on the other hand, if the father said, hey, kid, I know you're mentally unstable, but here's an AR rifle you get to keep under your bed unsupervised, well, that's a different fact pattern.
Yeah.
And so it depends on how the facts develop. If the facts need not be a super complicated case for the prosecution.
Yeah, true. We're talking with Andrew Branca. I keep wanting to say the wrong vowel for your name, Andrew Branca.
Either is fine.
I
Don't worry
know.
about
You
it.
know, my last name, I feel your pain, my friend. I get it all the time. Who is a self-defense attorney and expert in this field. This, because I know in the Crumley case, the prosecution had to prove whether or not the mom knew, the parents were aware that the son had this, I guess, murderous predisposition or this intent or inclination to go out and murder people, and that's what they're going to have to, because I understand the involuntary manslaughter charge, but did the dad, I mean, was he aware that his son had murderous tendencies? I mean, that's something they're going to have to explore.
Yeah, I mean, listen, I had my first rifle when I was 9 years old, and I could just take it into the woods and shoot it whenever I wanted, and I didn't kill anybody. So if the child's not inherently dangerous, as far as I'm concerned, there's nothing wrong with a child having access to a firearm. The key has to be, there's something wrong with your kid. Unfortunately, we live in an era where there appears to be a lot more unstable kids out there for whatever reasons. I'm not a doctor, but we didn't have school shootings like this when I was a kid, and we all had unfettered access to firearms.
Yeah.
Our dad's gun cabinets were just cabinets, like a china cabinet, where with glass, so you could admire the firearms from a distance, and anybody could open them up. And the ammo was right there in the drawer. We all had unfettered access to guns. None of us did this. But in this day and age, if you know your child's mentally unstable, it's only the responsible thing to do to make sure they don't have access to firearms.
Yeah. And then there's the question of local law enforcement had visited the house, I guess, a year prior, because the kid was accused of making death threats on Discord, but they couldn't, I guess, determine that it was, absolutely him, and the dad was defending him. And then after that, he gets his son this rifle. I mean, if you're law enforcement and someone's making those death threats like that, like, where is the line? Someone's making death threats. They're saying, I'm going to go to my school. I'm going to shoot up my school. I'm going to murder these people. I mean, with some degree of specificity. And I realize that, we have the whole fighting words and all of that, and some speech is protected, some isn't. But at some point, at least at the very least, you're the parent, you have to intervene if law enforcement can't. But when the parents don't intervene, what is law enforcement left to do?
Yeah, and my understanding, too, is that this was a single-parent household, so we have that level of instability there as well. In a sane world, short of course, if there's probable cause for a crime being committed or threatened, there's things law enforcement can do. But short of that, we don't institutionalize people anymore against their will, no matter how dangerous they present themselves to the public. Just walk through any major urban center and you'll see tons of people who probably ought not be walking around publicly in the streets because they're dangerous to themselves and they're dangerous to others. But it's been decades since society's been willing to institutionalize people like that for their own benefit, as well as the benefit of society. And this is partly the result that we get now.
So what is the application of this? I don't know if I want to say that it's a precedent, if I want to describe it like that, or if it's just, you're applying criminal negligence laws and, the penalty of that if the facts will out. But is there, because I had a listener that made the comment, does this mean that we can start going after gangbanger parents, to make it consistent? And it's not, I mean, I understand their point. It's not a bad point, but you still, again, have to prove that culpability and that, I guess, facilitation, if that's the correct way to describe it.
Yeah, and so in theory, you could. I mean, if those parents are providing their kids with the guns and they know their guns commit violent crimes, their children commit violent crimes when they have those guns in their possession, it's the same theory of recklessness. The somewhat surprising charge here is not actually the involuntary manslaughter one, but the murder one, because the murder charges are predicated on that charge of child cruelty. You saw there were multiple charges of child cruelty. One of the ways, and I'm not sure I've seen this in other states, in Georgia, to get to second-degree murder is when a death occurs in the course of cruelty to children. And when I look at the statute, it looks like the way it's supposed to apply is someone's beating their child and the child dies of the beating. They didn't intend to kill the child, but they're going to make it more than manslaughter because it was a child that you were killing. They're going to make it second-degree murder. It looks like they're trying to get to second-degree murder for the father by arguing that he facilitated, it looks like, the child cruelty to the children in the school, not to his own son.
Interesting.
Yeah, and that, I think, is going to be a more kind of precedent-setting argument for the prosecution to make in this case. That I haven't seen before.
It seems, I wonder if they're kind of over their skis a little bit on that, because isn't that sort of the way it works when you're going into trial? You don't want to bite off more than you can chew, so that you do at least get some kind of conviction if you're the prosecution.
Maybe by the time they get to trial, but in this kind of horrific case, and let's say it up front, obviously the school shooting is an absolutely
Right.
horrific case. The people who died are completely innocent victims of a monster who walked amongst them. Um, the prosecutor has every incentive to go over their skis here. I mean, this is for both for legal and political purposes. This is something they'll be inclined to want to do. It'll be up to a court to check them if a judge wants to check them and not allow them to proceed with this legal theory.
Last question for you. Do you think that we're going to start seeing, I mean, heaven forbid, I don't want to see more of these tragedies. No one does, but we do unfortunately live in a culture that, law and order has broken down, and we just, people are just horrible to each other by and large anymore. Is this going to be the new normal in terms of going after and maybe looking at the either activity of the parent, the involvement of the parent, and whether or not they are culpable in these cases? Do you foresee more of this?
I would expect every prosecutor moving forward, even from Crumbly, when a young person in the custody of a parent commits a violent crime, especially a high-profile violent crime like this with a gun, they are absolutely, first thing they'll do is look and see, did that kid get the gun by the willing provision of the parent? And if they did, the parent's very likely to be criminally charged.
Wow. This is such a sad case. I would imagine they're going to get a conviction, at least on one of these charges with this father, for sure. It's just, I mean, it's a sad case. It was preventable. Andrew Branca, always appreciate you, my friend. Thank you so much for your expertise, and you can find him at
Sure thing.
lawofselfdefense.com. Thank you. Good to see you.
Thanks.